Good afternoon, colleagues, and welcome to the Risk Management and Insurance module of the PMT course in 2024. My name is Thomas Harben. By way of background, I am an admitted attorney. I was admitted in 1997. After practicing for just over a decade, I took up in-house roles. I've been with the LPIIF since 2009. In 2009, it was still called the AIIF. I joined the company as the claims manager, and then from 2011, I became the general manager. A huge part of my job is the management of risk, both the management of risk for the company as an entity, as well as risk management in legal practices. I hope that in this module you'll learn some practical tips that you can apply in your practices, and that the module will also highlight some of the risks that practices face. So we'll cover the main risks faced by the legal practices. We'll also look at some of the appropriate measures that can be implemented in practices to mitigate the occurrence of those risks or those risks materializing. We'll also look at the types of insurance cover that's available to legal practices. We'll spend quite a lot of time dealing with the LPIIF, that's the Legal Practitioners Indemnity Insurance Fund, and the Legal Practitioners Fidelity Fund, that's the Fidelity Fund. And lastly, we'll talk about an appropriate manner of approaching the assignment and the quizzes, and also look at some of the available risk management resources. Just a few house rules. Please do not communicate with me directly. Any communication with me should be in the forum on the eLeader platform. If you send me emails directly, I will not answer them. For the sake of transparency, as well as to give everybody the benefit of the doubt, all communication must be on the eLeader platform. I'll only answer questions relating to the course content. Administration-related queries should be sent to the team at LEAD. So please do not send me emails that you cannot submit your assignment, or you are unable to complete the quizzes or requests for extensions. Those should be submitted to the team at LEAD. If it's something related to the content of the course, if there's something you do not understand, please send those questions through the eLeader platform. This is not an assignment that you can just take a shotgun approach. By shotgun approach, what we mean is that you can just put any amount of material in that you think is vaguely relevant, and hope that something will be correct. That's not a prudent approach to the course. Please watch all the videos, the entire video of this presentation. Also read the course manual, and look at what is posted in the forums each week. That will really assist you. And this presentation is not going to just go through the manual. That you can do. The aim of this video and the presentation are to go into the depth on the selected topics only. Dishonesty has been a big problem in previous years with candidates undertaking this course. Plagiarism will not be tolerated. Also, collusion between candidates who work together on assignments and submit identical assignments, those will be picked up. Dishonesty will be reported to the Legal Practice Council. We've also identified those candidates who have just copied assignments from that had been submitted previously, but in other intakes. So please avoid those. I'll be available for 2 hours each week on the e-leader platform to answer your questions. So please post questions, content-related questions on the e-leader platform, and I will answer them. We'll start with an introduction to the risk management. What we mean by the risk management is that it's a process in terms of which the risks faced by legal practices are identified, the likelihood of the risks materializing are assessed, and then as well as the potential impact of the risks, and we then design mitigation measures. Mitigation measures are measures that help us to either avoid the risk occurring, or will assist us in mitigating the impact of the risks when they do occur. No two legal practices will have an identical risk, will be identical when it comes to risk. You need to look at factors such as the areas of practice, that's the type of legal work the firm undertakes, its size, its structure, geographical location, how long it's been operating, and most importantly, the culture of the firm when it comes to practice and risk management. You cannot avoid all risks. Law firms do not operate in a vacuum. So there are risks that we just cannot avoid. If you take, for example, as I record this, South Africa has just gone through, is in the throes of the longest the longest period where we've been subjected to load shedding. Load shedding affects all firms, whether they have backup systems or not, and that's something that we all currently cannot completely avoid. Don't view risk management as just another level of bureaucracy. Risk management assists you to run your practice better. It protects both you and your clients. And don't just use it go through it as a tick box exercise. Use risk management in order to enhance the manner in which your practice is managed and conducted, and also use it to enhance the service that you offer to your client. Everybody in the firm has a role to play, from the partners or directors right down to admin and support staff. Even messengers, for example, have a role to play. If a messenger were to deliver a document late, and as a result thereof, a matter that the firm is dealing with were to prescribe for example, that would have significant implications. My point with that is just that you need to emphasize the importance of risk management to everybody in your firm. Lastly, if we look at what the good governance codes prescribe, the King 4 prescribes that the governing body, that's in the case of law firms, the partners or / directors would need to govern at risk in a way that supports the organization in achieving its strategic objectives. You will never be able to take your firm in the strategic direction that you intend taking it if you don't manage risks. If a risk materializes, it could have a significant impact on the firm financially. If you need to pay a claim, there could be regulatory action by the legal practice council, or your reputation could be at stake. So risk management will help ensure the sustainability of the firm. As I mentioned, it helps you achieve your strategic goals. It will also assist in meeting the regulatory requirements applicable to law firms. And if your risk is managed properly, you won't face claims. Well, the likelihood of you facing claims will be lower. The likelihood of you being called to disciplinary action, to disciplinary hearings by the Legal Practice Council will be lower. And because you won't be dealing with the consequences of risks materializing, you can spend more time concentrating on the practice of law. Where a firm faces a professional indemnity insurance claim, for example, or any other claim, the attention of the practitioners and staff is then diverted from running the legal practice to dealing with that claim or with the disciplinary hearing at the LPC. When your time and focus is taken away from practice to deal with those, the achievement of your strategic goals and helping to build a successful firm, that your focus will be taken away from those. If you have a positive risk profile, your insurance premiums will be lower. When insurance companies base their premium on the risk, if you take your household or office insurance for example, insurers ask questions like whether you have burglar alarms, whether there are burglar gates and other measures aimed at restricting entry into the practice, whether there are security guards. All those affect the risk profile of the entity, and if an entity is more risky, the insurers will charge a higher premium for that. So, and an entity that has good risk management systems in place can buy insurance at a better rate than an entity that is more that is viewed as riskier. Also, you'll save money. It costs money and time to pay claims or to deal with any of the other consequences of a risk materializing. And risk management will give you an advantage over your competitors. If clients these days have a huge choice, there are currently just over 31,000 practicing attorneys in South Africa. So clients have a wide pool to choose from. One of the factors that many clients take into account is how firms manage their matters. That's about risk and practice management. If in your bids to clients or talking to potential clients, you emphasize how risk is managed in your practice, how you manage the execution of mandates, that could be what separates you from the rest of the wide pool of practitioners. And lastly, it saves your reputation. Disciplinary actions against attorneys, as well against all legal practitioners in South Africa, are public. All you need to do is go onto the LPC website and you can click on the page with the disciplinary hearings, and you can see a whole list. That list is available to any member of the public, even potential clients. You'll see we'll go through a number of cases, and the cases that we cover, unfortunately, there's names of firms that are mentioned there, and fairly or unfairly, some people could use that information to decide whether they would instruct the particular firms or not. So avoid claims, avoid disciplinary action, so that the only publicity that there can be out there for your firm will be positive publicity. Where do the main risks in legal practice lie? First of all, is failure to comply with statutory time limits. We'll spend a lot of time dealing with prescription. Secondly, is cybercrime. That will also cover at length, as will be theft of trust funds and under-settlements. A failure to carry out mandates is another common mistake. Non-compliance with the regulatory requirements, people either not educating themselves on what the regulatory requirements are, or simply ignoring them. Or just on the point of regulatory requirements, it has been rather concerning in previous years that candidates in the PMT course still refer to the Attorneys Act. The Legal Practice Act came into operation on the 1st of November 2018. It's one piece of legislation that governs our profession. It's only 120 sections. Please read it. And please, in your assignment, do not refer to the repealed Attorneys Act. And then the inadequate management of support and of support staff, and as well as professional staff, is also a problem that we have identified. This list we've come up with when we've looked at the underlying causes for claims against legal practitioners. Just an indication of the LPWF claim stats. At the end of December 2023, we had over 720 million in outstanding claims. That number should be concerning because it's been going up each year, and we are now will soon be approaching R1 billion in outstanding claims. And what are some of the main areas of concern? You'll see them from this pie chart. Conveyancing, prescription of RAF matters. General prescription is the prescription of non-RAF matters. If in terms of these are the claims reported, but if we have to look at payments, in the last 5 years, the claims, 59% of the claims that we paid related to RAF prescription are a sum of RAF prescription and general prescription matters. So prescription is a huge issue, and we've dedicated a huge amount of our resources to assist practitioners to manage this risk, but somehow it is still not being managed as we would have liked it to be. And to have 2,222 outstanding claims against a profession of the size that we have in South Africa is a concern. That number excludes the claims that have been finalized already. So if we look at some of the common errors, I just want to highlight this: a failure to carry out a mandate timelessly, and then I would also to highlight those that relate to a failure to deal with matters timelessly. Claim not lodged within 3 years, claim not lodged within 2 years, that relates to RAF matters. Summons not served timelessly. These are all matters that relate to time management of the mandates that firms carry out. And if you look at those numbers, you'll see why prescription is a huge problem and why there's so much emphasis insofar as the management of matters is concerned. Since 2007, there's been a steady increase in claims against the legal profession in South Africa. And this is attributable to a number of factors. First, there's a lack of adequate risk management measures in a lot of firms. There are unfortunately many colleagues who aren't even aware of what risk management is or why it's necessary. We also had the emergence of new risks. Cybercrime, with the LPWF first started being notified of cybercrime related claims in 2010, and they were targeting mainly conveyances. Also bridging finance, which is bridging finance related claims were also against conveyancers who had signed undertakings in matters where bridging finance had been applied for. And just for those colleagues who do not know what bridging finance is, in a conveyancing transaction, I'll take a typical example. A property is being sold, and in order for the transfer to go through, you need to get clearance certificates. So the seller may be owing monies to the municipality, they may be owing levies or even owing SARS, so they cannot get a clearance certificate. In order to clear those arrears and also then receive a clearance certificate, the seller will go through to the bridging finance market. There are several entities that offer short-term loans, and on the understanding that once the property is transferred and when transfer is registered and the proceeds are paid out, that the bridging finance company will receive its money. What bridging finance companies do is they request that the attorney sign an undertaking, and a lot of that's how those ended up in claims against the attorneys, because sometimes the attorneys would pay the money out to all parties to whom monies were due, but not pay the bridging finance company. There were also issues of fraud in some conveyancing firms where the attorneys themselves or even their staff would apply for bridging finance without the seller being aware. The profession has also grown. I mentioned that there are currently just over 31,000 practitioners. In 2009, when I joined the LPWF, there were only 18,000 practitioners. The profession has grown, but the cake, the legal market, hasn't grown in step with the growth in the profession. The result is that there's increased competition. We have people undertaking work that's outside of their areas of expertise, and also those that feel that let me put it this way, there are also those practices who realistically are unsustainable, and because the attorneys are struggling, they aren't investing time, effort, or money in putting in appropriate practice and risk management systems. A lack of supervision of staff, just leaving staff to go on and deal with the work, and attorneys overly reliant on paralegals, legal secretaries, and the like, and not properly supervising them. Society has also become increasingly litigious. Gone are the days where what lawyers said was just gospel. Consumers have become more aware of their rights, and they are also more aware now that they can take action where necessary against legal practitioners, where they are dissatisfied. And those actions may be, in some cases they are justified, in other cases they aren't. When things go wrong, it's easier to blame your lawyer. And lastly, as other areas of work like RAF work is drying up, firms have identified professional indemnity claims as a new area where they could make money. And This is, as you'll note from media reports, there's been an increase in claims being brought against hospitals, whether it's public hospitals or the private hospitals, as well as the members of the medical profession, because that has become a new area of work, and some people see it as quite lucrative. So lawyers haven't been spared that. Also, the economic recession. At times of economic recession, let me rephrase that. Times of economic recession internationally are followed by an increase in claims against members of the profession. And the reasons for that are varied, but if people did not achieve, if we use the legal profession for example, if people did not achieve what they thought they would after they had instructed lawyers, they try and make up their losses by suing their former lawyers. The coronavirus pandemic is behind us as a health issue, but we still see the after effects of that, both on the economy, on the way that legal practice is conducted, and also on how people choose on whether to engage as a lawyer or not. The way law firms operate is different now. There are many firms that are using a hybrid system of working, or using remote means of working. Pre-COVID, I would have done this presentation to you in person in various venues around the country. Not all law firms were geared to operating in the post-COVID manner of operating, and not all areas of legal practice enable us to work in this manner. There were also a number. COVID was a huge business interruption, load shedding, disruption of municipal services, another business interruption. These affect law firms. Last year there was an explosion in the Johannesburg CBD, the gas explosion. Consider if there were law firms in the buildings around the epicenter of that explosion. They wouldn't have had access to their offices, and thus wouldn't be able to operate. That's a business interruption. And also I've addressed the question of whether there's adequate work to support all legal practices. And then we've also noted that the formal education system, so what law graduates leave university with, is not necessarily enough for them to be successful in practice. There's a gap in practice, and as a lawyer, you need to be many things. You are a manager of a business, you're a professional service provider, you need to be an entrepreneur, you need to be head of the administration of a firm, you need to be head of operations, and sometimes you even need to dabble in issues like IT. You also need to be your own financial manager. So all those skills are not skills that we leave university with. These are skills which we have to pick up in practice if we haven't studied them or gained them elsewhere. And then lastly is the mental health and psychological issues. Colleagues, as much as we'd like to believe, as lawyers we aren't superhuman. We are affected by stresses like everybody else. And if you look at what while we are dealing with those stresses of of life, our eyes are taken off the ball from our legal practices, and that's when errors can be made. It's very, very important that we look after our own mental health as well as the mental health of our staff. The legal profession is really a pressure cooker environment. The attitude of sink or swim, the attitude of simply get on with it, is prevalent in the profession, and all those are not really helpful to us as legal practitioners, or even to our staff. Okay, in session 2, we'll go into how we can manage the risks in our practices. What we'll cover in this section, colleagues, is first the internal controls and then managing the engagement with the client. I've just switched my video off because you'll note that the image was covering some of the text on the slides. You'll recall that from the slide 9, that a failure to carry out mandates correctly and a failure to confirm instructions were highlighted as errors or omissions that lead to professional indemnity claims. We will use the tips on managing the engagement with the client in order to address that. We can address that risk if we proactively manage how our relationships with the clients from the beginning. It will also assist in managing client expectations, reducing uncertainty for both the firm and the client, and protecting the firm's interests as well as those of the client. One of the best ways to manage your engagement, by managing the engagement, is managing the relationship with the client, is by using a letter of engagement. Some people use different terms for it, but it's effectively the contract between the firm and the client, whether that contract is written or not. Though you'll note that we suggest that a written contract with the client for all matters is preferable. Just talking about clients, just some things to be aware of. Beware of clients with unrealistic expectations. Clients with unrealistic expectations are those where, if you're dealing with a litigious matter, they think that first of all that they will win at all costs, and secondly, insofar as the damages are concerned, the client has an inflated and unrealistic expectation of how much they'll receive. It's very common. It happens very commonly in personal injury matters. A client who has terminated the mandate of more than one lawyer in the same matter is also a cause for concern. It's if possible, or actually probe with the client why they terminated the mandates of the previous lawyers, and try and assess whether the reasons were justifiable. And if the client is just generally unhappy with the legal profession or the administration of justice, or the client mentioned it in the previous bullet point, who has terminated the mandates of a number of lawyers and has expressed the view to you on how useless and ineffective the previous lawyers allegedly were, it's only a matter of time where you will be added to that list as well. And clients who are heavily personally involved in matters, I'm not saying that, but what I mean with personally involved in matters, these are clients who want to dictate every aspect of what happens in the matter, not just the outcome. They want to dictate every step that's taken. They want to dictate the strategy that you are adopting in the matter. And these are clients who, in many cases, pursue matters on the basis of principle, as they say. And those are clients who would use expressions like, I don't care what it costs me, I just want to teach the other side a lesson. If you are unable to teach the other side a lesson, the client will then lay the blame with you. And those are the clients who are very quick to report matters to the Legal Practice Council or bring a claim against you. And those are the same. Those that want to dictate strategy are those who want to co-lawyer with you. Sometimes clients they would watch TV series or watch movies about the legal profession, and they think that they can, based on that, they can be also be co-lawyers in the matter. Would you be careful of those? The clients who dump lots of documents on you, I've listed there, because these are the type of people that bring you lever arch files or boxes or even suitcases of documents. Doesn't matter whether they are relevant or not, and you are expected to spend a lot of time reading through all those documents in order to ascertain what is relevant and what is not, and also what the actual issue in the matter is. Also be careful of clients that tailor make a version in order to achieve an outcome. So you may explain to the client what the legal requirements are on a particular point, what the procedure is, and what needs to be achieved in each step of the matter or in the matter as a whole, and a client that conveniently changes their version in order to meet what you've explained that they need to achieve. Those clients, please stay away from those. The clients are a risk. And also those clients that are very demanding. As I stated in the presentation, I don't know whether it's polite to call clients needy, but I think they are needy. Those clients that show up at your office without making an appointment, who phone you at all times of the day or night, whether you are busy with something else, and clients who are not interested in ascertaining your availability, those you should please try and stay away from, because they expect you to be immediately available to deal with their queries or to work exclusively on their matters. Lastly, serial litigators. There are clients who have a long history of lodging complaints against lawyers and also instituting action against members of the profession. Those, please stay away from them, because it's only a matter of time before they will come after you. So, having said that, if you avoided all the categories that I've raised in the previous slide, and you decide that you will take on the matter, our recommendation is to record the terms of your agreement with the client in writing, in what we'll call, for current purposes, a letter of engagement. Others call it a terms of mandate document, or the name of the document is not important. I think It's the principles and the content that are. So what are some of the matters that you can include in your letter of engagement? First of all, is the scope of engagement. Set out exactly what the firm is instructed to do. If you are dealing with a commercial matter and you are instructed to draft a contract between two parties, that set out that the instruction is to draft the contract between the two parties, and that's what you'll do. If you are litigating in a personal injury matter, a claim against the RAF, set out that you are dealing with the claim against the RAF. You're not dealing with any other claims. For example, if the client's vehicle was damaged in the accident. Last example I'll use there is with matrimonial matters. If you were instructed to deal with the divorce only, set it out. You don't want clients coming afterwards in a matrimonial matter to say, oh, yes, my divorce was finalized, but my former spouse was supposed to give me half of their pension. I see that they've now squandered it, and you did not go and on the basis of the clean the clean break principle, you did not get my share of their pension or provident fund. In the first example I gave of a commercial matter, if your job is only to draft the contract, it's not your job to go and do due diligence in the matter. Set that out in the scope of the engagement. Also record who the client is. That's the name of the client. If the person that's instructing you is acting in a representative capacity, record that in your letter of engagement. And also on that, in order for you not to run into problems later with the authority, ask the client to provide a documentary proof of their authority to act. If it was a curator or a parent acting on behalf of a minor child, ask them for their ID and for the child's birth certificate. If it's a curator, ask for a copy of the court order. It's also very important to deal with client identification and verification. FICA is more than just a copy of the client's identity document and the proof of their address. You need to read the act, read the regulations, and ensure that you have a system in place to deal with those. There are a number of there is guidance on the LSSA, the Law Society of South Africa website, on dealing with FICA. There are guidelines on how you can deal with FICA. Set out who in the firm will deal with the matter. This enables the client to have a single point of contact rather than phone different people in the firm. If you expect to use counsel or another expert, please set that out. And then importantly, fees, expenses, and billing. This is often where the breakdown in the relationship between the client and the attorney comes, when it comes to issues of fees. And those Section 35 of the Legal Practice Act hasn't come into effect yet. Please read that section of the Act, particularly the subsections 7 to 12. They set out what needs what attorneys will in future be expected to discuss with client. It's good to use those now, even though the relevant section hasn't come into effect yet. But if you use that as a guide and document the discussions you have with clients in that regard, it will really avoid disputes in future. If you are acting in in terms of a contingency fee agreement, incorporate that into your letter of engagement. And then, very importantly, your letter of engagement must contain the firm's banking details and those of the client. And once again, insist that the client provide you with original bank stamped documents. Do not accept emailed documents, because cybercrime is a reality, and the cyber criminals also produce what purport to be bank statements with bank stamps. So ask the client, even when the client phones you to make the appointment, just give them a list of what they should bring, including the original bank stamped documents. Please remember that point when we deal with cybercrime, as well as when you deal with the assignment, because there is a cybercrime related question in the assignment. Also set out the circumstances under which the relationship can be terminated, whether it's by the firm or the client, and the consequences thereof. So what happens to the matter after, if the relationship breaks down, issues regarding fees, if your mandate is terminated, or if you decide to withdraw from the matter. Also put in a dispute resolution clause. In the dispute resolution doesn't need to be complicated. If the person that's servicing the client is an associate in the firm, you can state that in the event of a dispute, the matter will be escalated toward a partner or in the firm. And just when I refer to partners, I'm also referring to directors of incorporated practices. And if I refer to attorneys, I'm also referring to trust account advocates. So those are the advocates practicing with trust accounts. If there are counterparts to the document, address that and ensure that both the document is signed on behalf of the firm and dated, and also signed by the client. Be careful of situations where the firm signs the document, sends it to the client never signs it and sends it back, and the firm just starts working on it. In the event of a dispute, the client will say, but I didn't sign the document. If there are changes along the line to the mandate, please draft an addendum and get all the parties to sign and date those as well. When you prepare your letter of engagement, explain each term to the client. If necessary, use an interpreter. If, for example, it's a contingency fee agreement, make sure that your contingency fee agreement complies with the terms of the Contingency Fees Act. And also look at what the rules say. The rules that are quoted there, rules 35.3, 35.4, and the relevant sections of the Act, which prescribe that on receipt of instructions from the client, the attorney must ensure that the intended scope of the agreement is set out with sufficient clarity to enable the attorney and the client to understand the full extent of the mandate. And in the event of uncertainty, the attorney must seek written clarification. If the firm will be holding funds for the client in trust, and those need to be invested, the investment mandates must also be recorded in writing. You don't want a client suing you, saying that the money was held in your trust account, whereas the client intended it to be held in an investment for their own benefit. Some of the resources that you can look at that are relevant to engagement management. If you look at the previous editions of the Risk Alert Bulletin, going back to 2009. You'll find numerous precedents for letters of engagement that you can adapt for use in your practice. The Risk Alert Bulletin is available on our website, www.lpwf.co.za. You click on the Risk Management tab, and then if you scroll down, it says Risk Alert Bulletin. You'll find those. The August 2021 edition of the Risk Alert Bulletin contains a checklist that's been tabulated, so it's in table format, which you can use to develop a checklist for your practice. And then you can read the other resources that I've referred to there. But what I would emphasize is please look at the precedents in the previous editions of the Risk Alert Bulletin starting from 2009. Look at what is stated in that August 2021 edition of the Risk Alert Bulletin. And on the LPWF website, there's a comprehensive document on risk management. Please read it. It also has precedents in it. And one of the questions in the assignment relates to letters of engagement. So please have a look at that. We'll now go into some of the internal controls that can be implemented in a firm. One of the internal measures that we recommend is the use of file audits. These are not the audits that are done by the auditors as part of your annual trust audit or your firm's auditors when they come and audit your business accounts. These are audits. This is just a measure of checking files to see whether everything that should be done has in fact been done, and whether the matters are progressing as they should. Every file in the attorney's practice should be audited at least once a year. You can do this periodically if you choose to do it monthly or quarterly, or if you wanted to coincide with your performance appraisals in the firm, you can do that. And the files don't all need to be audited in one setting. You can choose a sample from each department if you want to just a certain number of files and look through them, if it's not practical to do them all at once. And by conducting the file audit, you'll be able to, firstly, you'll be able to see whether in each file there has been a letter of engagement that has been signed by the firm as well as by the client. You'll also be able to see whether the matters are being attended to timeously and whether the standard of the service provided is at the required level. You'll also be able to proactively identify potential risks before they materialize. You'll be able to take corrective action timeously, in other words. And it will also give you the assurance that all the functions in your practice are being to meet the regulatory requirements. You do not want to run the risk of the LPC saying that you did not properly exercise control over your practice, or that you are not properly supervising staff. You can also use the file audit process to check the financial functions to see that they are all in order, and that there's a proper audit trail for all the financial transactions in the file. The outcomes can be used by you to identify areas that require improvement in your operations, and you'll also be able to identify personnel that require additional training. The benefits of regular file audits, you can assess the level of compliance and whether the people in the firm are complying with the firm's minimum operating standards or standard operating procedures. An early alert system for areas and unethical or unprofessional behavior, appraisal of performance, as I've mentioned. You would also use it to assess the effectiveness of your supervision, and it will also assist in assessing the level of effectiveness of the risk management and mitigation measures that you have in place in the firm. And annually, the LPIIF requires that firms complete a risk management self-assessment. That's the form you complete when you apply for a Fidelity Fund certificate, but it can also be downloaded from our website, and you can just complete it, even if you do it periodically just for yourself and do not submit it to the LPIIF. You'll be able to see how effective your risk management measures are. And it will also assist you in detecting matters that your firm is on record of, where your firm is on record, but you are not aware of. In one of the resources that I'll show you in a later slide, a practitioner was sued for a matter where his firm had been instructed and the matter prescribed. That practitioner was not even aware that the firm had accepted the mandate and was dealing with the matter. So in order to avoid skeletons like that falling out of your cabinets, I'd rather do file audits regularly. And how do you do a file audit? You can develop an audit checklist. And the file audit must be done by a senior member of the firm. Don't let the people dealing with the matters do their own file audits. That self-review doesn't really assist. If you want to develop an audit checklist, we've given you this a precedent on the LPIIF website. If you click on that link, you'll find a precedent that you can use. And also, it's prudent to do an audit before you close the files to ensure that you tie up any loose ends that in the matter, so to ensure that the mandate has been fully carried out and that there's been a proper accounting and reporting made to clients and any other third parties. When you look, some of what you should look for when conducting the file audit is to ensure that the Financial Intelligence Center Act has been complied with, that the letter of engagement has been completed, the mandate has progressed without the unnecessary delays. Remember what I said about the prescription-related claims and failing to carry out mandates timelessly. Also check that there's been regular communication with the client. If the client was requested to provide information or documents but hasn't been providing that, you'll be able to follow that up. Maintaining firms in accordance with the firm's operating standards. This it just means that the firm's operating standards are essentially just a list of what people should do and when. So, for example, you can have a document, and it can even be on a single page. It says that after receiving an instruction, within 24 hours a file must be opened. In a certain period after that the letter of engagement must be signed by by both parties, that so people just know what to do. And the file should tell a full story of the matter. So that if somebody who's unfamiliar with the matter in the firm picks it up, they should be able to read the file and easily to get up to speed. If there are gaps in the file, that should be a cause for concern. Also, you could check that your firm's billing policies have been complied with, and there's been a proper accounting, and any trust deposits and the management of trust monies are done properly. You can also check whether the law has been correctly applied to the facts and whether there are any prescription issues or gaps in oversights in the handling of the matter. You can, if your firm runs separate departments, you can have a separate checklist for RAF matters, for example, or conveyancing, or commercial, or even administration of estates if your firm does that type of work. But look at the template that we have on the LPII website. And then file notes and file order. Disorganized files, as the state there, are fertile grounds for errors and omissions to occur. As part of the process in dealing with claims at the LPII, we ask practitioners to give us their full file of papers. Sometimes when we receive those files and files are disorganized, then it becomes clear that something was bound to go wrong in the matters, because the files are just disorganized, they're not properly managed. Secondly, you can ensure that there are detailed file notes and file notes that are taken contemporaneously. What we mean there is in a consultation with client, whether it's physical, whether it's on the phone, or in a discussion with the opposing party or anybody else involved in the matter, make notes of the important points. If there's anything that is required for the other side to do, for the client to do, or even for the firm to undertake, make a note and put a date on it for by when the further action is to be taken, and follow it up with correspondence. We dealt with a matter a few years ago where the attorney provided us with lever arch files, lots of documents, and he had detailed file notes in the matter. It then transpired on the day before the matter was supposed to go to trial, the attorney was being sued by his former client, that he had made up those file notes. They were all fraudulent, and as a result, we couldn't run that trial for the attorney. Needless to say, that matter cost the attorney a lot of money. File notes will assist you if there's, in the event of a complaint to the Legal Practice Council, where there's a dispute about your fees and about the work that has been done in the matter. It will also help serve as to assist with your defense in the event of a claim against the firm. And it also helps when the matter is transferred from one person to another inside the firm. Useful resources. So when it comes to file notes, that article in the June 2020 edition of the Risk Alert Bulletin, the matter I spoke about where the attorney was sued in a case where he wasn't even aware that his firm was dealing with the matter, is discussed in the October 2021 edition of the Risk Alert Bulletin. In this matter of P.J. Ninaba versus Pierre Kitching attorneys and another, it was the attorney's file notes which assisted in running his defense, and that claim was successfully defended by us. And as I've indicated, there's a file audit precedent on our website that you can attach. What do we mean by a peer review system and supervising staff? A peer review system is really this I've taken from the audit environment. Auditors have a system where before they sign off any report, the report is reviewed by another partner in the firm. I know that in law firms it's not always practical, because people often ask me what happens if they are sole practitioners and just have a secretary. But even in that case, you can review the secretary's work before it goes out, in the same way that the secretary can review your work before it goes out. So the peer review system will assist. It's because you have a second pair of eyes that's cast over the work, and it also assists where you are chasing up multiple deadlines, and thus not able you may make mistakes because you cannot concentrate fully on one matter. You may miss something, so you avoid matters or particular actions required that are required from you falling through the cracks. And a lack of supervision of junior staff is something that has been highlighted both in the claims notified to us as well as in several judgments. As I've mentioned, even in small firms you can use it. Experienced secretaries, candidate attorneys, paralegals can really assist you. It will also give them an opportunity of training, and it will also mitigate the risks that flow from the handover when a person leaves the firm. Often when we are notified of claims, practitioners then say that either the candidate attorney or the associate or even the partner who dealt with the matter previously didn't inform them of the matter, and they only became aware of the matter when they were doing a spring cleaning of the office and found allegedly files hidden under desks or hidden behind cupboards and so on. And if you have a file where there's been no activity for an extended period, please consider closing those files. Obviously, write to client, inform the client that you're closing the file. If there's any further action that needs to be taken, advise the client accordingly. One author in the US suggests states that in his practice, what it does, if files have been inactive for a long time, he has a system where the file is then transferred to someone else, and that person needs to at least do one action on the file before it's transferred to a third person, and so on. And it says in that way they revive files. But files that are dormant for extended periods could be potential risks, so rather close them. Invest in training your staff. We've published an article about this in Day Rebus in the last quarter of 2023 that deals with the importance of training. And segregate duties, particularly financial duties, and do not give one person an over-concentration of authority. What I mean there is, do not give one person the power to request, to requisition a payment, to authorize it, and then to release the funds. Rather have a segregation. It will help mitigate with cases of debt. It will also help mitigate with cases of paying people incorrectly, where it's a legitimate mistake that has been made. And thirdly, it will assist you when it comes to cybercrime. Once again, practitioners often ask, how do we have a segregation of duties if you have a sole practitioner and a secretary, for example? If they are the only two people in a practice, you can still do it. If one person is dealing with in those cases, the practitioner needs to be the person in control of and the only person with access to the bank account. But the secretary can then do a check before the amounts any amount is paid, by checking whether the amount that you are paying is correct, whether you are paying the correct party, whether the banking details have been verified, and also the reason for the payment. And before you make any payment, ask to see all the documents related to that payment. Do not rely on people's word. I would say people do say to you, you need to make the payment urgently, and then they'll bring you the supporting documents later. Empowering your staff to manage up in the same way that you manage your subordinates. Also empower your staff to manage you and to keep you on your toes. Empowered staff can really be an important asset in the firm. They may pick up errors that you haven't, or they may pick up practices that you've developed in your firm that are inefficient or put your firm at risk, and then come up with suggestions to mitigate those. Some of the resources that you can look at, the articles in Direbus that we've listed there, will assist you in dealing with the matters covered in the previous slides. We now would move on to looking at the main risks facing legal practices. We'll cover the current operating environment, cybercrime. Please take particularly note on cybercrime and prescription. Undersettlements, that's undersettlements of matters which I'll explain, and then theft of funds and regulatory and compliance matters. These aren't the only risks faced in legal practices, but I've just thought it's important to highlight these as the main risks that legal practices face. Cybercrime, prescription, theft of funds. Please pay particular attention to those. So I'll start with the coronavirus pandemic. I know some people think that it's something that has happened and that we've moved on, but there are still lingering effects on those from the pandemic. It had a significant impact on our lives. Legal practice wasn't spared. Unfortunately, sadly, legal practitioners died, staff in law firms also passed away or lost friends and family members because of the pandemic. Law firms couldn't operate optimally during the lockdown period. It was particularly restrictive, and law firms couldn't operate as usual. There's always the risk that they couldn't attend to mandates appropriate at that time, and clients could institute action against them. Prescription became a particular risk during lockdown because documents couldn't be served in order to interrupt the running of prescription. Some law firms were better geared than others to operating during that period, and those law firms still are. That's why you have some firms that operate on a hybrid basis, or people are working remotely. Even those have their risks. If you're operating in one of those systems, please be aware of the potential risks. And then some types of work were worse affected than others. There are some types of legal work that you can undertake no matter where you sit, and as long as you have a computer and a connection to the internet, you can still carry on working, whereas other types of work require the lawyer to have face-to-face meetings with clients. If you take criminal work, for example, you cannot run a criminal practice remotely, whereas a lawyer that is just drafting agreements for clients and doing certain types of commercial work, it's much easier for them to do it. Conveyancers need to lodge documents at the registrar, at the deeds registry's office. People doing administration of estates need access to the master's office. The closure of the master's offices and the deeds registry's office was a huge problem. There were times when courts were closed during the COVID pandemic. Sheriffs only providing limited services. It's the prescription issue that I've spoken about, as happens with the closure of the RAF offices at that time, when people could not submit their claims to the RAF by the prescription periods. And the coronavirus pandemic caught us all unprepared. Some practices have had to close down abruptly, or have had to downscale in the wake of the pandemic. That has had an impact on the staff. So in some cases, staff were retrenched, and that included legal practitioners themselves. The staff that were left in the firms were then expected to do more work with less hands available, and that is another risk that we must be aware of. So you need to ask yourself, look at how your firm has operated in the wake of the pandemic. Use those lessons to chart your future strategies and how you'll be able to deal with similar interruptions in future. There's an increased use of technology, but that brings new risks, particularly cyber crime. And not all of us, unfortunately, are tech savvy. And ask yourself questions like, how will prolonged illness, and whether it's not COVID, because as a health pandemic, as I've mentioned, it's largely behind us. But you should ask yourself, how will, if a key person in the staff were to be unavailable for a prolonged period due to illness or even death, how will your firm be affected, and how do you ensure its sustainability? And have you, in that regard, have you considered buying insurance solutions such as key person policies? Unfortunately, the many insurance companies still refer to it as a key man policy, but it's a policy that will be able to assist you in the event that the firm loses income due to illness or death of a partner. And also look at whether you have a business interruption policy in place. If not, consider it. Remember the example that I gave of the gas explosion that occurred in Johannesburg in 2023. If there were firms that were affected by that and did not have access to their offices as a result, if they had business interruption policies, they would those policies would kick in. So think of those, and also ask if you do have a business interruption policy, look at the wording, see whether it covers losses flowing from the pandemic. But it's not the COVID pandemic, whether it's any similar pandemic in future. So these are just a list of resources that you can look at related to COVID. Dunjana versus the RAF. That case involved a matter that prescribed during the hard lockdown period, and the plaintiff in that firm successfully overcame the RAF's special plea of prescription. The article in the June 2020 edition of the Risk Alert Bulletin contains a whole host of cases and legal principles that can be argued if a firm is faced with a special plea of prescription for a matter that prescribed during the hard lockdown period. These cases, the Guard Risk, Cafe Chameleon, Ma Africa, and the other cases listed on this slide, all deal with insurance litigation, where in respect of whether business interruption policies will indemnify the insured parties there, because they couldn't operate during the COVID pandemic. There's still a lot of litigation going on around the world regarding coverage, whether insurance policies should refund people for losses that they suffered due to not being able to operate during the lockdown periods under COVID. Insofar as the economic environment is concerned, I'm not going to dwell on this, because, as I mentioned earlier, the law firms do not operate in a vacuum. When there's economic recession, unfortunately means that clients become more selective first of all, in whether they should use legal services, and then secondly, which legal services they use. They have tighter budgets, and as I also mentioned, the trend around the world is that after a period of economic recession, there's always an increase in claims against the law firms. Just some of the significant events I'd like to highlight there is that the changes at the RAF, with the introduction of the Board Notice 58 in 2021, then Board Notice 271 in 2022, the RAF's termination of its previous panel that had 102 firms, all those had a significant effect on the legal profession. The bulk of litigation in the country is, if you look at the court rolls, is against the RAF. If you look at the number of accidents that there are, injuries on South African roads, you'll also be able to see how that doesn't only that what happens at the RAF doesn't only affect the lawyers. It affects the claimants involved. It affects the families as well. As I record this, there is a challenge to the RAF's Board Notice 271 of 2022. The LPWF has launched a review application, and that application will be argued before a full bench on 26, 27 and 28 February 2024. But I think that what is stated on that slide, a lot of it is self-explanatory. And then when we move to the next slide, ask yourself what will happen if you lose any key staff. How will that affect the firm? This is just generally, if people leave, are those that will be left behind? Will those who are left behind then be expected to to do more with less hands to assist them? Will your firm still be sustainable in the long term? How long can your firm survive if the current operation circumstances persist? And what measures or changes or reserves do you have in place? That article published in March 2021 also addresses some of the issues. If you look in the practice management column of De Rebus, there is an article that I wrote a few years ago on why law firms fail. If you check through the practice management column that you can get on the De Rebus website, you'll be able to find it. If you'd like a link to that article in particular, please send a message on the forum, and I will then post a link to the article on the forum. So, business interruption, please, when you draft your risk management plan, include risks flowing from business interruption, and if you have a business interruption, going back to the Johannesburg gas explosion example, and you can't access your offices, or will you still be able to operate, and how will it affect the completion of mandates, both the time it takes you to complete the management as well as the quality of the output, and flowing from that your income. Just something else from business interruption is how would it affect your training program? How would candidate attorneys be trained? It's one of the lessons from what happened during COVID is that with the remote working and the hybrid working system, training programs in many firms for candidate attorneys were affected. When you work from home, you lose the advantage of just walking into an office and running something by a colleague, or asking a colleague for advice on a matter. The staff, in many instances, are left to their own devices, and literally and figuratively. And then also, working from home requires a certain level of discipline, of dedication to their work. So those you also need to consider. So every business enterprise, including a law firm, must have a business continuity plan. So a business continuity plan is how you'll continue operating if your premises burnt down, or there was a gas explosion in front of them and you couldn't of the premises, and you couldn't access the premises, or even if you didn't have water or electricity at your office for a long time. So start planning for things like that. And as part of the business continuity plan, you must have a data recovery plan. It's very difficult to have a data recovery plan if you're still using physical files and not using technology. It's much easier if you're using technology and your files and other documents are stored electronically. At least you can access them. Train your staff on the business continuity plan and the data recovery plan. It doesn't help to have such a plan and you keep it to yourself and nobody knows what to do in the event of a disaster. Your business continuity plan must include how you communicate with clients and other stakeholders so that they know that you are still open for business and still dealing with their matters. And load shedding I've mentioned, but it's just a question to you. Have you considered what would happen if you were working on a matter and due to not having electricity for an extended period, you don't have your computers don't have power, or your server crashes and you lose the work that you've already done, and firstly, or you are unable to meet a deadline that is looming. So it's really important to think about having a backup plan for electricity. Those you can use. I don't think I need to explain the need to have other electricity sources of power, or to use these like devices like inverters to store power for times when you don't have electricity. But something else you could think of, you could consider is there are a number of entities that provide emergency office space. You could investigate those. If your premises you're operating from are leased, ask your landlord whether they have alternate space that you can use in the event that you cannot access your office. A lot of the larger landlords have have arrangements in place to move their tenants in the event of an interruption to the leased premises. And then municipal services can also be a problem. If you don't have water at your office, that's a health and safety issue, and I think that one speaks for itself. And just on the issue of alternate premises, make sure that the alternate premises are on a separate electricity, water, and an ICT grid. It doesn't help if you don't have water or electricity or telecommunications at your office, and your alternate office is on the same grid and is suffering from the same problem. You can take out business interruption insurance. When you purchase that insurance, inquire from your insurance broker or intermediary whether the policy covers costs associated with procurement of alternate business premises. Some policies do. Whether loss of profits will be covered, and then what is called the increased cost of doing business. So if it means that it's going to cost you more money in operational costs to move to alternate premises, check whether that is covered by your business interrupted policies. A lot of business interrupted policies only cover you where the loss flows from a physical destruction of premises. For that reason, a lot of insurers say that they won't cover you for losses arising from load shedding, for example. And also ask about future pandemics, even if it's not COVID, but because many insurers then change their wording after the COVID pandemic, but ask about what any future pandemics will be covered. We will now deal with cybercrime. And please take very important note of what is stated in respect of cybercrime, both for the assignment as well as also for measures that you can implement in your own firm. As I had mentioned, the LPIIF first started receiving notifications of cybercrime related claims in 2010, and in the period following that there was an increase. The South African legal profession was being targeted in the same way, or is being targeted in the same way that lawyers around the world and all other businesses are being targeted by cyber criminals. In the COVID period, there was an increase in cyber-related crimes as people were working remotely, but that has continued even post-COVID, and so there may be several reasons for this. These include that The checks and balances in payment processes were relaxed with remote working conditions. That's both in the case of the law firms, their clients, and other parties were making payments to law firms or were due to receive money from law firms. There's also been a lack of supervision of staff, including the staff responsible for the making of payments. IT security measures for staff working at home may not be the same as at the office. People at home may not have the same security settings, firewalls, etc. as firms have in place. There's been a substantial increase in the efforts by cyber criminals to penetrate both firms and individuals. If you would just look at the number of SMSs we get, you could, for example, get an SMS saying that your bank card is about to expire, and then you have to click on a link. Those are all phishing efforts by cyber criminals. And then there's sometimes also a decline in the levels of alertness to cybercrime and cyber scams. Careful of those emails that say that there's a refund due from SARS or payment due to SARS that has to be made. Any email that's or SMS that says that you need to make a payment urgently or you need to log on urgently. If you get an email purporting to be from your bank, don't click on the link. Rather pick up the phone and phone your bank. Don't phone the number that's on the SMS or the email. Phone the number that your bank has on its website or the number you have on record. And then payments being made in a hurry. If you rush through to make payment, or you act on an email or SMS threat that a payment needs to be made, or those are the types of cyber scams that you need to be aware of. So there are different types of cybercrime attacks. Ransomware attacks are where the cyber criminals effectively virtually take over your firm and you're not able to operate, and they say that you have to make a payment in Bitcoin, failing which the information from your firm will be sold on the dark web. That's a ransomware attack. So the cyber criminals take over your firm and hold it to ransom. Phishing is just a system that cyber criminals use in order to phish information from you. So those come in the forms of the SMSs and the emails where they want you to log on and put in your credit card details, your account details, and passwords so that they can take over your account. Hacking is similar to ransomware, but with hacking, put simply, they just break into your IT system. Then business email compromise is sometimes referred to as payment fraud, but what happens in business email compromise, and this business email compromise is the most common type of cybercrime that has been hitting law firms in South Africa. This is the email, this is the cybercrime where an email is sent giving banking details into which funds must be paid, and that's the email is a fraudulent one. So let's look at this case study on business email compromise. So I'll read it. A is selling her property and instructs BCD Incorporated attorneys to attend to the transfer. BCD Incorporated attorneys accept the instruction, and as part of the process of onboarding the new client A, obtain her banking details. Her account number is 1234, held with Big Bank. As the transaction progresses, BCD Incorporated communicate regularly with A on her email address, aclient@gmail.com. The transaction is finalized and BCD Incorporated attorneys need to pay the proceeds of the sale to A. A few days before the payment was made, BCD received an email from A. Please note that you look at the first email address. Client is CLIENT. In this one, it's ACLEINT. The point there is that the cyber criminals can just change one character in the email address. So it's a client, but client is spelled incorrectly, purporting to be from A. The email refers to the matter being attended to. That's because cyber criminals do that. They make it look real. That's why they refer to the particular matter. And instructs BCD Incorporated to pay the proceeds of the sale into account number 98766 held with Huge Bank. The email states that A intends closing her account with Big Bank. The email also gives a phone number different to the one the firm has on record for the staff at BCD Incorporated to contact the sender in case they have any queries. The team at BCD Incorporated acted on the emailed instruction and made the payment into the account at Huge Bank in accordance with the instructions in the email and send proof of payment to that address. A few days later, A contacts the firm wanting to know where the funds due to her are. The firm sends her the proof of payment, but she says that she has not received the funds and that she did not send the email. A instructs another firm to litigate against BCD Incorporated to recover her money, and BCD Incorporated's problems start. So, 3 questions for us to consider. Firstly, do you think that BCD Incorporated is liable for the amount claimed? Secondly, did the firm do anything wrong in acting on the instructions in the email? What do you think? Thirdly, if the firm is liable, what steps can it take to mitigate a similar loss in future? On the case study, in my view, yes, the firm is liable and will be liable to compensate A for a loss. And the liability could be based on a breach of mandate. That's a claim against the firm in contract. Breach of a duty of care, or negligence in other words, that's if the claim is framed against them in delict, or a fiduciary duty they have to A. And also, I think they did do something wrong, and that they will thus have to compensate her. Well, when we look at what has happened with cybercrime business email compromise claims in particular, what the cases say, there's Howden versus Edward Nathan Sonnenberg's. In that case, Mrs. Howden was due to make a payment of over 5 million rands to ENS in order to do. She was purchasing property, and it's that payment that Ms. Howden was making to ENS that was intercepted by the fraudsters, and she sued ENS. Her claim was based in contract, and the court in Johannesburg, the High Court in Johannesburg, found the ENS liable. and ordered them to refund. At the time of recording, that matter is the subject of an appeal. If, as and when the matter is, the appeal is argued and we get a judgment on, judgment is handed down on in that appeal, I will post in the forums if that happens during this intake of PMT on what the outcome is. Please read that ENS judgment, the Howden versus ENS judgment, to see what happens and how the fraudsters operate. You'll also be able to understand the basis of liability. Apologies, in that matter, the firm was not sued in contract, but rather in delete. So apologies for that. That ENS is Howden versus ENS. The plaintiff sued in delete. The judgment also gives an indication of the type of measures that the court felt the firm should have implemented in order to mitigate the risk of cybercrime. Read that judgment, because you'll be able to understand, first of all, how liability is framed in delete. Secondly, the modus operandi of the cyber criminals. And thirdly, some of the measures that can be implemented by firms in order to mitigate the risk of cybercrime. It's important that you read these cases, because one of the questions in the assignment relates to cybercrime, as well as the questions in the quizzes relate to this, and they'll ask. They are aimed at testing whether you've read these cases and whether you understand cybercrime. Hartog versus Daly. This Hartog versus Daly, where the cause of action was framed in contract rather than delete. Remember that in order a claim against an attorney can be framed in contract, delete, or as a breach of a fiduciary duty. So in Hartog versus Daly, the firm was paying monies out to the sellers, and those monies were intercepted and stolen by the fraudsters. Fourie versus De Jong and Van der Spey, Van der Spey and De Jong, in this another cybercrime matter affecting the attorneys. And in this case, you'll note that the judge also set out what the firm could have done in order to mitigate the risk, and the judge quoted from the risk alert bulletin. So look at that matter as well. Jürgens versus Volschenk also lists what the firm could have done. It was also a conveyancing transaction that was targeted. Galactic Auto versus Fenta, this one was related to, it was a transaction between two, where the plaintiff was purchasing a motor vehicle, and that was and there the payment, the invoice was intercepted, and so the payment was made to the incorrect party. Lochner versus Schaefer was also a matter involving attorneys. So at a bare minimum, please read Howden versus ENS Incorporated. Remember what I said, that matter is subject to appeal, but for now, unless and until there's a judgment from the Supreme Court of Appeal, please read this judgment of the court a quo. Read Hartog versus Daly. Read Fourie versus Van der Spey and De Jong. Jürgens and another versus Volschenk, and read Lochner versus Schaefer. As a minimum, please read those cases. There are other cases that are referred to in the manual. I haven't put them here because some of them involve parties other than the attorneys. So what can firms do to mitigate this risk? First of all, is you need to have knowledge of the extent, that's the frequency of the matters of the business email compromise incidents. The LPWIF is currently sitting with over 160 million, that's 160 million in claims, cyber-related claims that it has rejected. So that will, and that's only from the 1st of July 2016. That will give you an indication of how common it is. So if you know how frequent this happens, and you understand your obligations in terms of the Legal Practice and the Legal Practice Act and the rules, and also have documented policies in place to verify all payment instructions before making payment. That will help you. But some of the suggestions that you can consider is obtaining the client's banking details and original stamped bank statements when you take the instruction. Remember what I said when we spoke about letters of engagement. Also insist on a face-to-face consultation with clients where they hand you at least the first consultation must be face-to-face, and they must physically hand you the original bank stamp documents. If they say they'll email them later, inform the clients of the risks of cybercrime, and hand them copies of the risk alert bulletins that I'll refer to later so they can see. And incorporate that into your FICA verification process, that it will be face-to-face and original bank statements handed to you. Also inform the client and all other parties involved, so in a conveyancing transaction, if there are estate agents or valuers involved, inform them as well that you will not change your banking, you will not accept banking details sent via email. Add that as a condition to your letter of engagement. Banks and other financial institutions offer account verification services. You can use those. If there's any other recipient of funds, ask the person to come to your office physically with their banking details. If they need to change banking details, it must be done physically. Also be wary. If you're dealing with a matter, and I'll use a conveyancing matter, for example, because most of these cases relate to conveyancing transactions. If a party wants to change their banking details at the last minute, well, just before the payment is to be made, that should be a red flag. But we've been informed that the cyber criminals are also now targeting RAF claimants. Also, they ask the claimants to come into your office with their original documents, and don't accept emails suddenly from clients. Phone the client on the phone number that you have on record. Don't use that on the email address to inform the client that you've received an email purporting to be an instruction to change banking details. And when you phone the client, ask the client to also go have a look at their IT and their emails to see that they haven't been hacked. When I say client, to be anybody to whom the firm needs to make payment or who needs to pay the firm. You can also place a prominent email on all correspondence that the firm's banking details have not changed, and also alert them to the scam. I see a lot of firms do it on their email signatures. I've mentioned being alert to purported changes of banking details just before payment is due to be made. Have a documented internal procedure for staff so that they know what to do, and that documented payment procedures needs to also include what is prescribed by Rule 54.13, that's 54.13. I'll show you the wording of that rule in one of the slides. Educate staff and clients on cyber risk. When it comes to staff, you can even give them a copy of this presentation and copies of the risk alert bulletins that I'll show you. You can download them from the LPWF website. Get a cyber risk expert to conduct a gap analysis and to check your security. And cyber risks must be included in the assessments you do to comply with Rule 54.14.7. That's 54.14.7. We'll note from the previous slide that the other measures that we suggest are educating staff and clients on the dangers of clicking in links in documents from external sources or emails, or opening attachments in emails from unknown parties. That's where the cyber criminals bury the malware, and those are the emails they use for phishing. Sometimes in order to throw a sweetener in, the cyber criminals use effectively bait. They claim, make it sound like the email recipient has won the lottery, or an unknown person has left them a substantial amount of inheritance. And if you receive unknown invoices, correspondence purporting to be from SARS, a tender document, an invitation to submit a bid, or a new urgent instruction, please be careful. So with emails purporting to be from SARS, pick up the phone and phone SARS. Don't use the number on the email. And pornographic sites, gambling and bootleg music sites, and also bootleg movie sites are also high risk for malware. When you use public Wi-Fi sites, do not conduct your banking or other sensitive transactions on there, and don't use open public Wi-Fi sites, because you don't know what the security measures are. The LPWF and the LSSA website also have detailed cyber risk related information. Rule 54.13 states that a firm shall, unless otherwise instructed, pay any amount due to a client within a reasonable time. Prior to making any such payment, the firm shall take adequate steps to verify the banking details provided to it for the payment of amounts due. Any subsequent changes to the bank account details must be similarly verified. That rule places an obligation on firms to verify banking details and every subsequent change to banking details. So if you fall victim to business email compromise, and you paid out trust monies, you could also be found by the LPC to have breached this rule. Remember the Rule 54.13 when you deal with the assignment, as well as when you deal with the quizzes. But apply this rule at all times in your firms for any payment. If you look at Rule 54.14.7, which is quoted in the manual, and you comply with that in respect of developing your risk management framework and your internal controls that will assist with mitigating the risk of cybercrime. And if you fall victim to cybercrime and there's a deficit in the trust account, the shortfall in the trust account must be reported to the Legal Practice Councils to look at rules 44.36, 54.18, and 54.18.8 and 54.14.9. Also remember, read those rules and take them and consider them when you answer the cyber-related question in the assignment. A cyber attack may also, if your firm falls victim to a cyber attack and personal information of the parties falls into the hands of the criminals, you may be liable. Look at your potential liability under the Protection of Personal Information Act. Also read what your obligations are in terms of the Cyber Crimes Act. And then look at what King 4 says, Principle 12, the governing body, that is the partners in the case of a law firm, shall govern information and technology in a way that supports the organization being ethical and a good corporate citizen. Cyber crime-related claims are excluded from the LPWF policy. Read clause on X, that's Roman numeral 10, where cybercrime is defined in the LPWF policy. Clause 16C, which says that if it's a risk that should more appropriately be insured under another policy, such as a cybercrime policy, the LPWF policy will not pay. And then clause 16P expressly excludes cybercrime. And 16U says that if any practice conducted in violation of the Legal Practice Act, so it is excluded. Remember, if you pay out it incorrectly without verifying, that will be in breach of Rule 54.13, and thus in violation of the Legal Practice Act. Remember those exclusions when you do the quizzes and the assignment. Cybercrime can be insured in the commercial market under policies specifically worded for that risk. So they may it's a cybercrime policy that you can get. Some of them, or they would call it a cyber liability policy or something similar, but a cyber policy in the commercial market. And the way that the policy will be structured and the premium set will depend on what internal measures the firm has. The insurer may ask the firm to complete a questionnaire on what measures they have. Some cybercrime policies will only cover the insured if there's hacking. So if you can't prove that there was hacking, and then they won't cover you. So please look at the wording carefully. And if you, as a director of a law firm, are sued for a cyber breach, look at what your directors and officers liability policy says, because that a directors and officers liability policy covers directors of an entity. So if the claim is framed as a breach of your fiduciary duties, then your D&O policy will apply. If I was acting for a plaintiff, I would sue the law firm. I would frame my claim in contract, alternatively delict, alternatively breach of fiduciary duty, further alternatively that the firm, the directors will breach their fiduciary duties. Also ask your broker or intermediary about commercial crime policies. Sometimes commercial crime policies could have a certain level of cyber cover. And then look at the wording of your other policies, business interruption, public liability policies, to see if they offer any level of indemnification for cybercrime related claims. Cybercrime resources. These are the risk alert bulletins, February 2022, August 2018, and August 2019, that you can look at. Look at the resources referred to in the manual, and also read what is in the practice management column of the rebus. But I would start with these editions of the rebus, where it's expressed, it's covered in detail, and the cases I referred to earlier. The next main risk is prescription. One of the questions, what happens with the prescription claim? Commonly, a law firm takes instructions to litigate on behalf of plaintiff. The law firm does not serve summons in time, and the claim prescribes. That plaintiff will then sue the law firm for their loss. So how do you prevent prescription? First of all, before accepting instructions, ask yourself whether you have the appetite, resources, and expertise to pursue the instruction timelessly. If you don't, do not accept the instruction. Ask the client to provide you with all information and documents necessary to pursue the matter timelessly. Chase the client up if they don't. Register all your time-barred matters with the LPWIF's Prescription Alert Service. The Prescription Alert Service is a backup diary system that the LPWIF offers at no cost to the profession. You go onto the LPWIF website, www.lpwif.co.za. Click on the Prescription Alert page, and then register your firm, and then register all your time-barred matters. It's not only RF matters, any litigious matters, any matters where it's in the competition law, you can register them there. The system will send you updates, it will send you reminders of when you need to file, when the prescription date is, or any other statutory notification date is. And as you get the date looms closer, the number of notifications will increase. And please, so those notifications are reminders, please adhere to them. Take detailed and full and detailed instructions at an early stage in the matter. Act on client instructions promptly. Don't procrastinate. Supervise staff and check that all matters are attended timely. Regular file audits, we've already spoken about. Inform a client timelessly if a matter cannot be attended timelessly. Record that in writing, and if a prescription date is looming, point that out in the correspondence. And keep a copy of that letter as well as proof that it has been sent to client. Educate staff on prescription periods. If they look at statutory notice periods and periods for notice in respect of claims against the state. Study the law and know when prescription begins running, when it is suspended, and when it is interrupted. In the last 2 to 3 years, there have been numerous cases on that and what knowledge a creditor needs to have before prescription starts running. Read those cases. Regularly reviewing files that I've spoken about and closing them after advising clients. Peer review system we've covered. Don't assume that the prescription is 3 years in all cases. This is because, for example, with the RAF regulations prescribed a 2-year period for hit and run cases. The LPWIF successfully challenged the regulations. However, the RAF is still implementing those. So be wary of that and send them a copy of the LPWIF judgment if necessary. Have a dual diary system with your secretary, candidate, attorney, or paralegal, just so that there's a backup if something, and diarize prescription dates or when actions need to be taken. And then your secretary candidate, your paralegal, will also be able to check on you. Sorry, and that's what we mean by a dual diary system. Plead the correct course of action and institute action in the correct court. Check this, because what happens in some matters, the action is instituted in the incorrect court. It runs all the way to trial, and then the attorney realizes that they're in the wrong court when the other side has objected to jurisdiction or raised a special plea in respect of jurisdiction. They withdraw the matter, but by then 3 years have run and the client sues them. Be wary of tactics by your opponents. So if your opponent says that, you say to your opponent during negotiations that your client's claim will prescribe imminently, and the opponent says to you, don't worry about issuing summons, we'll probably settle it by then, don't take that. If they are agreeing to an extension of the prescription period, put that in writing, get both parties to sign it. So if you're suspending the running of prescription, clearly record it in writing. And it's important to note that it's the service of the process that interrupts prescription. Look at Section 15(1) of the Prescription Act. There are many practitioners that make the mistake of thinking that it's issuing the process that interrupts prescription, and that is wrong. Service, really. If you fail to use if you fail to register an RAF matter on the LPWF's prescription, let's the service that you comply with the reminders, the LPWF will levy a higher deductible. That's in Schedule B of the policy. Also remember that point for the assignment. Under settlements. What happens with under settled matters is that clients, an attorney runs a matter, usually acting for the plaintiff. The attorney settles. There are negotiations regarding settlement. The defendant makes an offer. The attorney accepts that offer, and the client, the matter is finalized, but the client, unhappy with the settlement, then sues the attorney because the client is of the view that they were entitled to a higher amount, or that the amount for which the matter has been settled doesn't adequately compensate them for loss. So do not rely on your power of attorney, no matter how widely worded it is, as your authority to settle the matter as you deem fit. Consult with the client on the implications of the settlement, and record the consultation in writing. Do that even if whether your recommendation is to accept or to reject the offer. Remember the once and for all rule. So this is in litigation. When you litigate once, when the matter is settled between the parties, the less between the parties has been resolved, the party can't come back and sue again for the same matter. So explain that to clients. If they're accepting the offer, they're accepting it. They can't come back later. Be wary of clients with unrealistic expectations. In personal injury matters, a client may start giving you examples of people that he or she knows who received huge amounts of payouts, whereas those circumstances would be different. Those parties would have suffered much more severe injuries than the client. So be wary of those that just want you to keep litigating and manage clients' expectations. Properly assess the quantum in a personal injury matter. Obtain updated medical, legal, and actuarial calculations. It doesn't help because litigation takes so long, your medical, legals, and actuarial reports are outdated or stale. They're commonly referred to. We've seen matters where by the time the trial date arrives, the medical legals are 7 years old and or even older, and yet the attorneys still want to rely on it. Run it offers by your experts as well to get their views. Be wary of pressures from your client's family members. Family members may be forcing you to accept a settlement which doesn't adequately compensate the client. If you're acting for a minor or a person that's unable to manage their own affairs, have a curator appointed to protect their interest. Sometimes you can leave the door open for your client to obtain a second opinion if they require one. So if the client says to you, you explain an offer of settlement to the client, and the client says, I'd like to think about it, or I'd like to discuss it with someone else, let the client go and discuss it, but also place a deadline by which they are to revert to you. Settlements at roll court and at the doors of court are particularly risky. This is because in those settlements and also so-called commercial settlements, what happens is that the defendant will state a figure that they're prepared to settle for. The plaintiff states a figure that they are looking for. The plaintiff will say that that's the lowest they'll go for. Defendant will say that their offer is the highest, and what the parties do is just decide to split the difference and say we'll meet halfway and shake hands on it. Be careful of those, because maybe it undersettled. Even if you're settling at roll call, and those negotiations that often happen in the passages outside, particularly at the High Court outside roll call court. Please, or when matters are stood down, phone the client and explain to the client what the offer is. Because many practitioners these days use smartphones, it's very easy. You can even record the call to a client and tell client that you are recording the call, so that will help you. Please read that article in the November 2018 Risk Alert Bulletin. Going on to theft, please study the Legal Practice Act and the rules. Know what your obligations are in respect of financial controls and your ethical duties. If your practice is not viable financially, consider closing it down. In the article that why law firms fail, I've listed some of the options available to firms that are not viable. So don't resort to messages. Do not resort to stealing funds, and have a segregation of duties in place that I've explained. Don't trust people blindly. Not saying to trust is good, but not to trust is very good. Do not trust people blindly. The example I often use is of a bookkeeper who never gets sick, never takes leave. It's always at the office, the first person at the office, every morning, the last person to leave, person who you can phone at any time and ask about any particular transaction, and the person concerned can give you a full explanation. Be careful of those people. They may not just be dedicated employees, they may be covering their tracks. Check all documents that are placed before you to authorize payments. Don't ask for explanations. Don't just accept everything you are told on face value. Does your firm have misappropriation of trust fund insurance? Misappropriation of trust fund insurance will cover the firm in the event that trust monies are stolen. This is very important. So, as the name of the policy states, misappropriations of trust funds insurance. So because criminals do not discriminate, they'll steal trust monies and or business monies. To cover business monies are covered, monies into your business account are covered by a separate policy that's called either a policy on own funds, because business funds are your own funds, or sometimes it's referred to as a fidelity guarantee policy. The word fidelity in the fidelity guarantee policy should not be confused with the Fidelity Fund. It has nothing to do with the Fidelity Fund. Remember your obligations to inform the regulator in the event of a trust shortfall. So if there's a theft, inform the LPC. We refer to the relevant rules in the slide on cybercrime. Rule 54.14.7 prescribes what internal controls you need to have in place. And then, importantly, theft claims are excluded from the LPIF policy. Please read that. The reason I've also added clause 16U or 16B says that if it's theft or unauthorized borrowing is just theft by another name. It's excluded. 16C says a policy that a risk that could be insured under another premium, including a misappropriation of trust fund policy. 16U says any activity conducted in violation of the Legal Practice Act. Theft, it will be a violation of the Legal Practice Act. And then clause 18 of the master policy excludes claims arising out of dishonesty. So theft arises out of dishonesty. Some of the cases you can look at, Lenzana versus Goodrick and Franklin. This is a case where the firm was instructed to pursue a claim against the RAF on behalf of the claimant. The firm did not do so. The claim prescribed. The firm was found liable. Schönberg versus Jacobo is the same. It's also a prescribed RAF matter. Dita versus ZRF Dean Attorney is also an RAF matter. Minister of Police versus Messina, prescription matter as well. And paragraph 17 talks about procrastination. And then you can read the other cases. Just want to highlight Fansel versus RAF. That's a constitutional court judgment that said that prescription doesn't run where the person is under, the plaintiff is under some sort of legal impediment. The LPIF versus the Minister of Transport and another. That's the LPIF case where the RAF's regulations for 2 years for hit and run cases, that's unidentified vehicles, was set aside. Please read the judgment, use it, send it to the RAF if they insist on the 2 years. Van Heerden and Bloemeyer versus Incorporated versus Bath and the McVillan versus Baychab, prescription of claims against attorneys. In both cases, the underlying claims were matrimonial matters. Stein Eno versus Ronald Bobroff and partners. This is an important case in setting out the test for liability. Lanyon versus Nikota SSH, that is theft, that was the underlying circumstances there were theft, but it also talks about the liabilities of directors in incorporated firms. You can just read through the other articles that are there. But there's the first matter, Bernard versus Dalport and Van der Merwe, and LaRue and another versus Johannes G. Coetzee. These deal with the prescription of the claim against the attorney. So what insurance policies can you look at? A professional indemnity insurance policy. Please check the wording properly. Professional indemnity insurance policy. It indemnifies the practice for claims brought against it arising out of the conduct of the profession. The LPII provides the primary layer of insurance to all legal practitioners in possession of a Fidelity Fund certificate on the date that the cause of action arose. And the LPII cover is automatically granted to those practitioners. The premium for the LPII cover is paid by the Fidelity Fund on behalf of the legal profession. Members of the legal profession currently don't make any contribution to the premium. There's an incorrect perception that paying money to the LPC is paying the LPII premium. That is not the case. It's not the funding model of the LPII. So it's the Fidelity Fund. It's funded by interest on trust accounts, and part of that, the money on that interest is used to pay the LPII premium. So we'll go delve deeper into the LPII in the next section. So over and above the LPII cover, firms can purchase professional indemnity cover in the commercial market, what's commonly referred to as top-up insurance. So remember, professional indemnity, if you want more than the LPII, you go for top-up insurance. Top-up insurance you place through an insurance broker, and sometimes when the firm is seeking to serve on panels of certain entities, they'll ask that the firm holds at a certain minimum amount of top-up insurance. You can that's when it can be bought from the open market. And the top-up cover kicks in if the claim amount exceeds that available under the LPII policy, or if the LPII policy has been used up, what is called expunged. If you want to see the differences between the LPII and the commercial insurers, read that judgment of the Western Cape High Court in Propel versus the LPII. The differences are explained there. So we'll want to do on insurance a risk transfer measure. So I just want to emphasize that this relates to professional indemnity insurance, not any other insurance. LPII covers all legal practitioners with Fidelity Fund certificates, and if the firms want additional cover, they buy top-up insurance. So it's cover topping up what the LPII has. So, for example, a firm with sole practitioner gets 1,562,500, 1,562,500 in cover from the LPII per year. If the firm feels that it needs more than that, it goes to the top-up. So if you have a claim for 20 million against that firm, for example, the LPII will pay it at 1,562,500, and then the top-up insurer will pay the balance. So please remember the structure. Other policies, cyber insurance cover, we've already dealt with that, to cover you with cyber crime, and then commercial crime policy, we've also mentioned. Misappropriation of trust fund, we've mentioned. Fidelity guarantee or theft of business, we've also mentioned. And then look at foreign insurance cover that probably covers your assets for fire, theft, water damage. Key person we've mentioned. Directors and officers, or what is called D&O commonly in the market, we've mentioned. Public liability. A public liability policy covers the entity if there's a claim for it. A common risk that's covered under public liability is if a visitor to your office, like a client or somebody coming to deliver documents, were to slip and fall in your reception because the tiles are wet, it's a public liability policy that will cover that. Loss of documents. Documents are very important to lawyers and their clients. If the documents are stolen or displaced, you can get a loss of documents policy. Business interruption, we also mentioned. A credit risk policy the firm can consider. It will kick in if the firm, for certain reasons, is unable to pay its creditors. Use an insurance broker that knows how the structure does for, as I showed on the previous slide, works. Some, not all insurance brokers know that, and be careful that you don't have brokers that just sell you any and every policy. Study the wording so that you and your staff know what is covered, what your obligations are, and when and how to notify a claim. Remember the principle of utmost good faith in insurance. When you fill in the documents for your insurers, please be honest. Common mistake law firms have is that they don't inform the insurer that they've had previous claims, or they don't inform the insurer that there are circumstances that they are aware of where there could possibly be a claim. Rather report too much than too little, because if you hide important facts, they'll jeopardize your cover in the event of a claim. Now we move on to the LPIF and the Fidelity Fund. The LPIF is a short-term insurance company. It was established by the Fidelity Fund in 1993. It provides the insurance, the insurance vehicle through which the insurance services listed in Section 77 of the Legal Practice Act are provided. It's a non-profit company, and as I mentioned, it's currently funded by way of a single premium paid by the Fidelity Fund on behalf of all legal practitioners. It's independent of the other structures in the legal profession. The LPC doesn't own this insurance. The LSSA does not own this insurance. It's an independent company. And reporting a matter to the LPIF is not the same as reporting it to the Legal Practice Council or to the Fidelity Fund or to the LSSA or vice versa. And as I mentioned, it was formerly called the Attorneys Insurance Indemnity Fund. The name changed in December 2018 after the Legal Practice Act came into effect, because the company then not only covered attorneys, but it also covered trust account advocates. The LPIF provides the primary layer of professional indemnity insurance, also provide bonds of security in favor of the master or the High Court to attorneys appointed as executors of deceased estates. Remember, bonds of security is only to attorneys, not to advocates with Fidelity Fund certificates. Look at Section 77(3) of the Legal Practice Act and you'll get the answer there. Risk management, we also provide risk management services to the legal profession, as in this presentation I'm doing to you. We publish material in Darabus, in the practice management column of Darabus, as well as in the risk alert bulletin. We could also come to training at your firm to you and your staff. All our services are provided at no cost. You can send us an email if you'd like us to come train you and your staff. That is free, and we'll come through wherever you are in South Africa. We'll come at our own cost. Please remember this diagram. LPIF, and remember we're talking about professional indemnity insurance. So please don't talk about top-up insurance if you're talking about misappropriation of trust monies. Top-up, professional indemnity insurance. What does the LPIF cover? With the terms of the cover set out in the master policy, it's issued once a year. The insurance year runs from the 1st of July of one year till the 30th of June of the following year. You can download a copy of the policy from the LPIF website. It's also in your manual. and it's a single policy. It's pays for liability to pay compensation to a third party. So if there's a fine or cost a bonus proprius or against a legal practice, that is not compensation, so it won't be covered. And the claim must arise out of the provision of legal services. So if you do any other work, and you see the definition of legal services, if you're running an an auction house from your law firm, or you are also doubling as an estate agent or property practitioner, that is not legal services, and that will not be covered. And the cover will only kick in if a claim is made against the insured firm. And who's insured? That's clause 5 and 6 of the policy. So it's every partner or director with a Fidelity Fund certificate on the date that the cause of action arose. So if a claim, for example, prescribes in the hands of an attorney today, the cause of action arose today, but the attorney retires or leaves practice, and then the client issues summons against that practitioner in a year's time, the practitioner will still be covered, because on the date that the cause of action arose, they had a Fidelity Fund certificate. And will only cover legal practice if you sole practitioner, a partnership of attorneys, incorporated legal practice referred to in section 34(7), and the trust account advocate. So if a law firm is conducted as a PTY limited or any other structure, it's not covered. If you want third parties like clients or anyone else can't claim directly from the LPWF, that's stated in the policy, but also read the Supreme Court of Appeal judgment in the Propel matter. Remember I said you must read the Western Cape Court judgment, that's the Court quo in this matter, which explains also that third parties can't claim from the LPWF, and the Court quo judgment also deals with the differences between the LPWF and commercial insurers. The SCA, the judgment only dealt with the fact that third parties can't claim, and you cannot cede your rights in terms of the LPWF policy, because a law firm purported to cede its rights to Propel Specialized Finance, a bridging finance company. And the amount of cover that the LPWF provides, it includes the current partners, so previous partners, or partners who have left the firm. Employees are also covered, so your candidates, attorneys, associates, secretaries, messengers, and then the estates of the persons referred to above. So in the unfortunate event that a partner were to pass away and there's a claim against that firm, the executor will then step into the shoes of the partner and report the matter to the LPWF. And liquidators and trustees are only covered if their appointment is made solely because they are legal practitioners, and the fees from their appointment are paid to the legal practice. So if the firms that set up a separate company to deal with liquidations and the like, that is not covered. And the amount of cover is determined by the number of partners in the practice on the date that the cause of action arose. People that are publicly held out as partners or directors will be considered as partners. So there's an unfortunate practice of fronting. If you hold people out as partners because you want to bulk up your firm or you want to improve your BEE rating, you list them as partners on your letterhead, they will be regarded as partners for purposes of the LPWF policy, and you'll pay a higher risk on that. On that point, please read the articles that I've written in the December 2023 edition of the Rebus, where I warn about the risks of those types of practices. The insurance year runs from the 1st of July to 30th of June, and It's important to note that the amount under the LPIF is an annual aggregate amount for the entire firm. It's not cover per partner or director. Remember that point when you do the assignment and quizzes. So this is the amount of cover. Depends on the number of partners. So sole practitioner, one principal, 1562500, and so it goes up depending on the number of partners. This is the amount of cover, the limit of indemnity, as it's also sometimes referred to. Then the excess payable is also determined by the number of partners. See, for all claims, you look at column B. But high-risk matters, you look at column A, and the high-risk matters are listed. Prescribed RAF and conveyancing claims, remember these are areas that will get a lot of claims. So if you have for example, a commercial matter claim, and you only pay the excess if the LPIF, if the firm is found to be liable. If the firm is not liable, you don't pay the excess. So if we're dealing with a commercial matter, for example, and the firm is found liable, the excess will be 20,000. However, if you're dealing with under the prescribed RAF matter or conveyancing matter, then the excess will be 35,000 if there was one partner in the firm. Number of principals is just number of partners. And then if you're dealing with a prescribed RAF matter and it was not registered with the prescription alert or the prescription alert system or reminders from the prescription alert system were not complied, it add an extra 20%. So instead of paying 35,000 rands excess, you pay 40,250. So please report the matters. Remember this issue of the additional premium when you deal with the assignment. If you want one document, short explanation of who the LPIF is and what it does, read those 10 frequently asked questions in the May Risk Alert Bulletin. In fact, I would say that should be prescribed reading. Just start there, and then you can look at these others. Who is insured? How much the LPIF covers, or how the excess works. But please, this May Risk 2022 edition of the Risk Alert Bulletin will answer a lot of the frequently asked questions. And it's short. You can read it within a few minutes and it will really assist you. So what is excluded from the LPIF policy? I'm not going to go through all of them. Trading debts, the most common example is if your client sues for a refund of fees, or the landlord sues for outstanding rent, of those are trading debts. Misappropriation of trust monies, this is because the misappropriation is covered by the Fidelity Fund, but the Fidelity Fund doesn't cover the attorney. It covers the victim of a theft, the owner of the money. Remember that. That's one of the differences between the LPIF and the Fidelity Fund. LPIF covers attorney only for professional indemnity insurance. Fidelity Fund does not cover the attorneys. It covers the members of the public, the owner of trust monies, whose monies were stolen by the attorney. If the risk could more appropriately be covered by another insurance policy, it's also excluded. This is appropriation of trust funds, personal injury, commercial and cybercrime policies. Remember those for your assignment. Judgments from foreign courts, investment advice, investments other than Section 86 for investments, fines, penalties, and then bridging finance. It will only cover bridging finances for transfer duty and cost, municipal water rates and services, or levies. I'm going to just skip forward. Remember, cyber crime we've already spoken about. legal services provided in violation of the Act. These my numbers here do not, please read the numbering in the policy. I just did a summary in the presentation, but look at clause 16. Also look at clause 17, fraudulent application for indemnity and dishonest or fraudulent or criminal acts. So what happens when if you faced with a claim? Let me just pause and explain. Because a claimant cannot approach the LPWF directly. Remember, LPWF, only the attorney, the insured attorney. So that's a legal practitioner with a Fidelity Fund certificate. So the attorney and trust fund advocate can lodge the claim. If you act for a claimant, if a claimant has, for a plaintiff who has a claim against an attorney or trusted crown advocate, do not cite the LPWF, don't sue the LPWF. Your client has no rights in terms of the LPWF policy. Proceed against that legal practitioner. That if the legal practitioner wishes to apply for indemnity from the LPWF, they'll notify it. And so if in the event that you as a legal practitioner then face the claim, what do you need to do? Give immediate notice of the circumstances that give rise to a claim. Sometimes it will be an actual claim, or you'll be doing your file audit and you'll realize that a claim is prescribed in your hands. Give the LPWF immediate notice. You must notify the LPWF no later than a week after receiving a written demand or summons or counterclaim. So if you just pick up circumstances, you would give immediate notice. But if you receive any of these documents, then you have 1 week. Also complete the risk self-assessment questionnaire and claim form that's prescribed. Don't cede, assign, or admit liability or settle a claim, because you'll compromise the position of the insurer. When it comes to cession, remember the proper specialized financial services matters. So do not cede your claim, and then you can also look at the website. That link will take you to the procedure for legal practitioners. If you act for a claimant, click on click on www.lpwf.co.za, go to the page for professional indemnity claims, and if you click on the link for the claims procedure, it will give you 2 options. For legal practitioners, so you're an insured legal practitioner, that you come to this one. The other option is for claimants. It will just explain to you that you cannot claim directly from the LPWF. Then, what do you do when you're faced with a claim? First of all, do not make any admissions. Recommend to the client that he or she consult with another legal practitioner because you are now conflicted. Notify the LPWF in terms of the policy, and if you have top-up insurance, simultaneously notify your broker. Retain your full file of papers and provide the client with a copy if requested. Prepare a detailed background report for the insurer and go into the details of the alleged breach of mandate. To cooperate with your insurer and the appointed legal team. The LPWF will appoint a law firm to defend the matter for you, over and above the limit of indemnity that the LPWF provides you. The LPWF will also pay the legal fees. So please cooperate with our team internally as well as the lawyers we have to appoint. Mention that the claims procedure is on our website. And if you're acting for a claimant, claim arises against the insured and not the LPWF. So do not cite the LPWF. And the test for liability authorities are set out in the manual. Moving on to the Fidelity Fund. This entity is a client protection fund. So The Fidelity Fund does not protect the legal practitioners, it protects the client. It's a fund it will only step in if money or property entrusted to a legal practitioner has been stolen. It's important to note it indemnifies the party who suffers the loss as a result of it and not the legal practice. It's also a fund of last resort. What this means is that the Fidelity Fund may insist that the client first exhaust all their rights. So if an attorney steals a client's trust monies, the Fidelity Fund may insist that the client take action against that attorney and obtain judgment and try and execute, and only if then the judgment remains unsatisfied, they can come to the Fidelity Fund. However, the Fidelity Fund has a discretion to waive that requirement, commonly referred to as the requirement that the attorney must be escused. If you have 5 clients who have suffered a loss because an attorney has stolen the money, and the first client goes through that process of sequestrating the attorney, it would be illogical to expect the other 4 to go through the same process. That's why the fund may has a discretion in regard to that. So when you say it's a fund of last resort, because it only kicks in after the action has been taken against the attorney. The liability and claims procedure are set out in Chapter 6 of the Legal Practice Act. Claims procedure is also set out on the website. To just summarize it, when the client becomes, within 3 months of becoming aware of the theft, or by the exercise of reasonable care, the client should have become aware of the theft, the client must notify the Fidelity Fund and the Legal Practice Council in the province where the attorney was practicing. The Fidelity Fund will then ask the claimant to complete an affidavit, or ask the claimant for a number of documents to substantiate their claim. The claims procedure is set out on the website of the Fidelity Fund. Apologies that reference is incorrect. It's not on the LPWF website. It's on the Fidelity Fund website. Just a warning, in previous intakes, what candidates have done in the assignment, they've just gone onto the Fidelity Fund website and copied and pasted. That is plagiarism, and for that reason they were marked 0 for the theft question. So read what is on the Fidelity Fund website, but also read what's in the act, and do not copy and paste. And that is the end of the presentation on the material. We'll now just talk briefly about the assignment. In the remaining few minutes of this presentation, I'd just like to spend time talking about the assignment. Please read the questions carefully before answering them, and then write well-reasoned answers and cite the relevant authorities in support of your answer. Do not merely copy and paste or plagiarize. If you refer to the LPWF policy, cite the applicable causes. And look out for risk management and insurance issues in each question. That's when they address those. Refer to relevant case law, statutes, and other authorities. And use the assignment to demonstrate your level of understanding of risk management. Some of the common errors that have been made in previous intakes are, first of all, dishonesty and plagiarism. As I've said in my opening remarks. Don't just plagiarize. If at this stage of your career you do not know how to cite authorities, and then you'd have a huge problem. If you do not know that you must use quotation marks when you quote from a work from someone else, then we have a problem. So I've also mentioned it in the opening, where we've picked up where people have submitted identical assignments, or people who have simply used an assignment that was previously submitted by someone else. Don't do that. For example, the question related to theft, we've noted that there have been numerous people who just copied and pasted from the Fidelity Fund website. Don't simply copy and paste from that website. Don't simply copy and paste from the Risk Alert Bulletin, or even from this presentation. That's number one. Secondly, with the writing well-reasoned answers. The one example I constantly give people is, if you've never drafted a memorandum or with legal advice, look at the Supreme Court of Appeal judgments and see how they set out and how they cite authorities. On average, a Supreme Court of Appeal judgment is 30 pages. So they are concise. The entire manual for this module is like reading one judgment. If we take out the LPWF policy on the end, the content is one judgment. Do not try and write and attempt the assignment if you haven't read the manual. We pick those up very quickly. And looking out for the risk management and insurance issues. We also pick up when, as I mentioned, the shotgun approach. People who just copy and paste a whole host of material and hope that something is relevant. Avoid that. This is not the type of assignment that you can start working on with a few hours left to go before the deadline, before the due date and time. Take your time and work on put in the effort and work on it properly. There are numerous candidates who have scored 0 in previous intakes, but there are also candidates who have scored 100% because they've done a lot of work. If you're looking at the tips to avoid prescription fraud, for example, copying and pasting from this presentation, from the manual, or even from what I've written in the Risk Alert Bulletin is not enough. If you do, please probably acknowledge where you've received it from. But also use your own tips that you may have developed in your practice to avoid prescription. That will also help. There are a number of candidates in previous years who've given very, very good tips from what they apply in their own practices. Also, the use of Google as or any other search tool as and trying to pass that off as legal research, that is just simply not enough. If we could find legal answers to legal questions by simply using Google, there would be no need for any of us as lawyers. Clients could also do that. The danger with using Google is that material crops up You use it not knowing whether the person who wrote it is even a lawyer or even a lawyer in South Africa. So be careful or just accept taking stuff that you find on Google. Another common mistake candidates make is when they're looking at the different types of policies, they use Google, the marketing material from the insurance companies pops up, and they copy and paste that as their answers. You would also not pass if you just use those. On the question of liability of legal practices, in previous years, candidates have copied and pasted from an article in Darebus that is wholly incorrect, and they copied and pasted it without reading it, and found that it was incorrect and didn't understand when they failed. Just another thing: do not phone either me or my colleagues at the LPIIF for assistance with your assignment. We've also picked that up when the people that have phoned the LPIIF. My colleagues at the LPIIF are aware of that. The article that I'm referring to in Darebus that I'd like you to please not use was published on the 1st of May 2021. It's titled The Legal Basis of a Legal Practitioner's Liability for Negligence in Execution of Mandate. That article, with respect, is legally incorrect. So please, if you use it, I know that then that you have not watched this presentation. In August 2021 or 2022, I published a letter in Darebus explaining the different types of insurance. I will put that in the forum as well, so that you can read it. It will help it. It's an article it's a letter, it's not long. It explains the different types of insurances. That will help with the insurance question. As I mentioned earlier, do not refer to the Attorneys Act. That Legal Practice Act repealed the Attorneys Act. The Legal Practice Act came into effect on the 1st of November 2018. If you, as a legal practitioner, you do not know the one piece of legislation that governs your profession with respect, then I think you have a huge problem. That said, please keep a lookout for what I'll post twice a week in the forums. Don't write to me about regarding the assignment or any administrative issues. Post questions in the forums, and good luck.